Would you like to call the case on, please?
Appeal in the matter of Montres Breguet S.A. and others, and Samsung Electronics Co Ltd. in Arnold.
Yes, Mr. Montres.
My lady, morning. I propose to take matters in the following order, the order of my skeleton: ground 1, ground 2, and then ground 3. So to deal with the use by Samsung first, and then deal with the issues relating to what goods it's used in relation to, and finally the commerce defence points.
Yes.
The starting point for ground 1 is to take the judgment, if you may, please. It's at core bundle tab 5, and to turn please to core 107 page. And
Which paragraph?
Paragraph 84.
84.
Yes.
Yes.
Now the judge began with an analysis of the correct case law. No criticism is made of this part of the judgment, and we say, nor could there be. The judge uncontroversially analysed the principal case law that was before her at that stage, the 3 CJU judgments in Google France, L'Oreal and Coty. The first of those she deals with at 85. You'll recall that's a case about Google AdWords and the bidding on AdWords and AdWord results in order to promote one's own brand. And it's a mechanism or a scheme that's operated by Google behind the scenes, so to speak, with visible results in the Google search results page. And the court in that case initially laid down the test of the user, the person's own commercial communication as constituting the basic test. And you can see that in 85. We don't need to turn the judgment up. The judge dealt with it very clearly. And in 86 is the actual test. This was because the use required as a minimum that an entity uses the sign in its own commercial communications. So this was sort of the first inkling that in advertising or in use, it had to be something that consumers were presented with. There had to be some sort of consumer effect. Then in 87, the judge went on to deal with the L'Oreal and eBay case, and it was a reference from the UK involving the well-known eBay marketplace, auction marketplace, and whether there were counterfeits and parallel imports in that place. The my learned friend dealt with this case in some detail yesterday, and there's no need to turn it up. But the judge essentially dealt with it in those paragraphs in some detail as well, also laying down the basic test that there has to be use by the advertiser, so to speak, or the seller, and it has to be a use in one's own commercial communication. So the test is fairly clear by that point, but it did already have a sort of a consumer-facing effect, and that's not something that we take any issue with. The judge then dealt with Coty, which was the last case, the most recent case that was before her in 89 and 90. And that involved sale of perfumes on Amazon. And what Amazon had particularly done was store the goods, but they had not stored them for their own sale. They'd stored them for the sale of others, and therefore the use was equally held not to be in Amazon's own commercial communication. So, of course, since the judgment in question, since the judgment appealed from, there's been the Louboutin case, which my learned friend went to some extent.
It's perhaps worth explaining that in Coty, the reference from the, I think if I remember rightly, was the Bundesgerichtshof, was on a very narrow point, and the judgment of the Court of Justice was equally narrow, and it was particularly focusing upon what they call the warehouse keeper.
Yes, one can see that in 42 of the passage that's extracted there. And 43, there's sort of a general language that's used in a lot of these cases, the fact of creating the technical conditions necessary for the use of a sign by others doesn't mean you're using it yourself. Now, when the Louboutin case, there was, I think, already the Advocate General's opinion before the judge, but I think, but not the judgment. But in any event, it wasn't taken account of. So the since the judgment, there was the Louboutin case that involved the famous French shoemaker who was and sales of shoes on Amazon, and an attempt essentially to control the sales outlets. Now, the issue in that case, as we've explained in our skeleton, was very similar to a case that arose some years earlier, Lush and Amazon, where the difficulty was that the results being fulfilled or presented or sold by, fulfilled or sold by Amazon were being mixed in with results by others. And therefore, there was a risk of the consumer considering that all of the results emanated from Amazon, or at least in part from Amazon, or Amazon were jointly responsible for them with the seller. Now, the issue in this case, of course, focused on that, but it was not confined to that. So my learned friend took you to the case, but I wanted to just point out a couple of additional paragraphs in it. If you take these, so it's JA 22, which is in your third. Sorry. And mercifully quite short, this judgment. But the point we wanted to make about this was, this has not sort of discarded own commercial communication or the previous case law, but it has to some extent developed it and emphasized the need for how the results or how the use appears to consumer. And that is important. Now, it's important not to, therefore, consider the case to be confined, or at least the test to be confined, to those kinds of cases. If you could pick it up, please, at 45. The court there is talking about the previous cases, and in particular L'Oreal and others. And they say the substance of which, it's true that in those paragraphs, the substance of which is set out in paragraph 30 of this judgment, the court did not expressly mention the perception of the user of the online marketplace to whom the commercial communication at issue is addressed. However, that does not mean that the court precluded consideration of the perception of users of the online marketplace as a relevant factor for determining whether the sign in question is used in the marketplace operator's own commercial communication. And that's important because we say it hasn't taken over the test of own commercial communication, but it's been clarified. And they go on to say, in the case which gave rise to that judgment, the website in question comprised only an online marketplace and did not also include sales offers of the operator of the site. And therefore, and they lay down a test, whether an advertisement published in an online sales website is using a sign identical with a trademark may be regarded as forming an integral part of the commercial communication, it's necessary to ascertain whether that advertisement may establish a link between the services offered by the operator and the sign in question on the part of the consumer. Now, we say that it's important to look on. So they say the overall assessment of the circumstances of the present case is the first part of the test. The method of presenting the advertisements, both individually and as a whole on the website, and the nature and scope of the services provided by the operator of the website are particularly important.
So I'm going to ask you the same question I asked Mr. Alexander. Would you agree with the proposition that what one gets out of this case, and in particular paragraphs 49 and 51, is that presentation is key?
Presentation is key, but it's not the whole.
To be sure, it's not
duty.
the sole consideration,
Not the
but
sole
it's key.
consideration. Yes, and presentation is key, and on the facts of this case was key, as it was in Lush. But in addition, other factors may come into play, and the overall circumstances of the case are to be taken into account. And in particular, the nature and scope of the services provided by the operator are very important. And if you look down at 52,
When you say the nature of the services provided by the operator,
yeah.
is that all services or only those which would be apparent to a reasonably observant consumer?
We say probably the latter. It has not been completely clarified because, of course, they always use language like "in particular" in all the circumstances, but we say it must be, or is likely to be rather. The position is that if it is something completely behind the scenes, it's difficult to see how it would have an effect. I think the example given in Samsung's own appeal notice is the contractual prohibition on infringement that is imposed upon sellers. We say that unless consumers are seeing that effect, or at least aware of that effect in some way, it's difficult to see how that's a factor. Now, turning to the basis of the appeal, you'll recall that the real basis of this part of the appeal is it is said that the judge's factors, if we then turn back to the judgment at, so that's paragraph 95, this is where, actually, the grounds of appeal, if I can summarise them on this, it is said that the judge was wrong to take into account Samsung's conduct as a whole, and in particular wrong to take into account the factors that she did, and that she ought to have taken into account different factors, the ones advanced by Samsung. Now, it's important to have a look at what those factors are, and they start at 95. So the initial one is, well, actually, I just wanted to emphasize this. I've reached the conclusion that Samsung did use the signs in the course of trade for the purposes of Article 9 of this regulation. I should emphasize that in reaching that conclusion, I've taken all the evidence relevant to this issue into account. And many of the features referred to below designed to make it easier for app developers to create apps and providing an environment under which apps could be uploaded, stored, and downloaded would not or would be unlikely to amount to use if taken in isolation, but that would not be the right approach. Instead, it must be correct to consider Samsung's conduct as a whole. And we say, in relation to these factors, that they all, or almost all, had a consumer output, so to speak, or a consumer effect. So if you look at the first of them, an initial and overarching point relates to Samsung smartwatches themselves and the way that they're marketed as truly watch-like, and also by reference to the wide variety of watch face apps. Obviously, that is something that consumers would be aware of. They would be aware of in advertising. They'd be aware of in potentially. Well, there was advertising evidence in the case that obviously supported that. And the wide variety of watch face apps, well, of course, they're all watch face apps, so they're all going to the same issue, and we say there's nothing wrong with that. It also connects Samsung with the apps on the store. So in this way, that of course, Amazon is a true marketplace, so to speak, selling products, an infinite number of and type of products for an infinite number of purposes, whereas these are all watch faces for the Samsung Galaxy Watch through the Samsung Galaxy Apps Store. So they have a single purpose, which is to go onto their own hardware.
So, if I've understood correctly, you're making 3 points there. One, Samsung is advertising. Secondly, Samsung is making them available through the store.
Yes.
And thirdly, it's for the Samsung smartwatches.
Yes, and I'm making a sort of fourth point, which is that informs the mindset as well. So that's the consumer. There's an effect.
Right.
So far as the next factor is concerned, she actually makes one of those points in 97. Samsung therefore specifically advertises the availability of a wide range of watch face apps in the SGA store. It clearly regards that feature as worth promoting. So the next factor is perhaps at 98.
We're just pausing at 97.
97, yes.
The last sentence of the paragraph. In the light of Louboutin, we've got a situation where Samsung produced watch faces are mixed up with
Yes.
other watch faces.
Yes, we have. That's a point I wanted to come to in a moment, because it depends on the way that you download the watch. The face. If you download it onto the smartwatch or if you download it onto a phone, you can do either. And I wanted to show you some pictures of that,
Right.
and also show you how the judge dealt with that. But it's so far at this point, she's not specifically referring to that. 98.
Sorry. Isn't that one of the things that she actually is saying?
Sorry, 97.
Is she's referring to the fact that there are both Samsung designed watch face apps and third party apps, and the latter are the majority.
Oh yes, to that extent she does. Yes.
Yeah. Okay.
Yeah. So the next factor would be presenting 97, presenting an attractive apps for the purposes of enhancing the functionality of the smartphone. And obviously that's something that does have an effect on the consumer. I mean, when I say an effect, it might not necessarily be stated to the consumer in the entry or the product listing. It's about, they may have a sense of it. And then 98, she refers to Mr. Lee's, that's Samsung's witness. His unchallenged evidence showed that there are additional reasons why Samsung's had commercial interest to host third-party apps, and in particular free apps. And as I understood his evidence, Samsung regards it desirable that free apps are developed and made available, because that highlights functions and interfaces that are unique to Samsung devices. So it's a sort of the freemium or free model. That will have an effect on consumers, because they will think that's good. I mean, obviously, that's good for showing the functionality of this device that I've just bought, and it's something that I'll think Samsung has a stake in, and not just a third-party seller. 99, I think is the next one. Yes. That's the same point. And then there's a factor that is perhaps borderline, which is 100. No doubt reflecting its commercial interest, Samsung provides material assistance to developers of watch face apps in the form of the Galaxy Watch Studio tool. That user-friendly tool was used to create all but one of the apps, and so on. And then there's the app developer conferences. And what we say about this is, this sort of provides a baseline of quality and usability for all of the apps on the store. And so it's sort of what they don't see rather than what they do for consumers.
Well, I mean, there are a couple of problems there, aren't there? First of all, does the average consumer know about any of this? And secondly, the cases allow an online marketplace to set technical conditions. What the cases discourage, or at least is what's described as individual assistance. And both the tool and the developer conference are not individual assistance, they are general assistance, if you
Yes.
like.
So there's two ways of looking at this. There's the relevance of this point in the e-commerce defense, and also it's a knowledge and control over the information. But so far as this aspect of the case is concerned, we say this is more about where they think those apps come from in a general sense. And if Samsung are essentially developing or imposing a baseline of quality and usability what happens there is that consumer goes onto the SGA and will never see something that's unattractive or doesn't work or glitchy and so on. Now, as I say, this is one factor. I think the judge even said this is not, some of these factors by themselves would not be enough. But as part of the overall picture, we say that this would have had a consumer output or consumer effect, so to speak.
So let me see if I've understood that submission correctly. Do I understand that what you're submitting is that in paragraph 100, the judge isn't suggesting that consumers would know this, but this is part of the way in which the Samsung SGA store works, which has an impact on what the consumers do see. Is that your submission?
Yes, that's exactly my submission. And 101 is also important because, and it's a point that easily gets lost sight of when we're discussing marketplaces and e-commerce defenses and so on. I mean, this is the store for Samsung products. You can't use it to download something onto your Apple or any other device. It is for Samsung products. And therefore, it's a sort of hermetically sealed environment. I think it's called an ecosystem. And therefore, there's an assumption, we say, far from the mindset that I know a friend painted yesterday of a sort of casual user buying third-party apps and knowing all about third parties and so on. There's an assumption here of a sort of quite controlled environment, we would suggest, controlled as to quality, controlled as to content, and so on. Now, there were some other factors that we say probably 101 is the sort of some of the nature and scope of the services that are similar to the ones in Louboutin.
Yeah, just before you go on, I've got a question about that, what you've just been submitting about the quality point. And I understand the submission. And this is just, as it were, a request for information from me. And the question is this: if you go back to paragraph 77, and reference is made there to the London taxi case and who the average consumer is. And my question is this: was the judge referred to the passage in that judgment where it's explained that the average consumer will be anyone who might think that the use of the sign in question is indicating something to do with some responsibility for the quality of the product or service in question? The issue in that case, as you will recall, was use of the sign use purely in relation to the service of hiring a taxi, or was it use in relation to the taxi as a good? And I'd taken the view that it was just use in relation to the service of hiring a taxi. The Court of Appeal said no, it will be referable to the taxi as a good as well, because if the taxi breaks down, then the consumer will be dissatisfied, and therefore there's an impact on the quality perception. Yes. So the question is, was that drawn to the judge's attention? Because
that particular distinction.
There seems to be some similar reasoning going on in 101.
Yes, I don't think that was specifically drawn to attention. I mean, some of those considerations, of course, come up under ground 2, because we're then dealing with a post-sale type of situation. But it was potentially, I think it might have been canvassed under the in relation to point. Yeah, but not on this point. But not specifically on the distinction that was drawn between the High Court and Court of Appeal on this particular point on ground 1. No. But we do pray and aid that point very much on ground 2. So at you recall I took you to Lewison and the point about sort of ancillary services provided by the marketplace. Well, the same considerations come up in 101. Samsung operates a store. It reviews all apps for functionality and content. Although customers may be able to download from other sites, the average consumer would understand, etc. Samsung, in contrast, apps available on the SGA store would be understood by average consumers to be made available by Samsung through its own store and to carry the implicit assurance that Samsung has satisfied them and ought to provide assistance in the event they prove problematic. Indeed, Samsung has specifically marketed its smartwatch by reference to the availability of watch face apps.
And one of the factors that the court took into account in Louboutin was that Amazon dealt with returns and queries about product
Yes.
quality and so on.
Yes. And I think that is the same position here, although I'm just trying to find whether the judge dealt with that specifically.
Well, we've got the finding in 101.
Yeah, it's as close as, I think it's as close as we get to it. Then, of course, the judge deals with the nature of the app itself. And this is a point that has come up at various points of the judgment and is potentially a key part of the reasoning, which is that we're dealing, this is not an app like a weather app or it might be whatever you've got on your phone. This is a watch face app. And the judge was clearly struck by the propensity for a watch face app to be assimilated to the watch itself and to indicate origin in just the same way a real, saying it politely, an analog watch potentially might, or some other categorization, might indicate origin. So, and that's an important point because given that Samsung make the hardware and the importance of the watch face to that, both in terms of its decorative value, but also in terms of its basic functionality, it's almost like a piece of system software. It's like as if, you assume that from the Apple App Store, you're not going to get third-party sellers of system software, or at least maybe utilities of some sort.
In the case that system software, because consumers may not be too bothered about who the real provider of the system software is, whereas here, it's the visible face of the watch.
It's the visible face of the watch, and it's not just the face. It's often you click on bits of the dial to get it to work by in various ways. So what the judge is really saying there is that this is the kind of app that one might expect Samsung to be making. And then in the next paragraph, it's the same point, developed a bit further. 103, when in use, the watch face app is the starting point for user interaction. And the distinction between Uber, the sort of Uber app, in the next paragraph. Now, again, another potentially borderline one is to be fair, the content review. But we say of that is, but in fact the judge says in terms, this is also linked to customer perception, so she clearly has that in mind in 106. And we say that that's the quality point again. And so you don't have to know about the content review, and in fact my clients didn't know about the content review until this litigation started. But you don't have to know about the content review in order to know, in order to have a sense of the sort of baseline level of quality. And the judge quotes from the CRG at the bottom of 106, which mandates that apps be valuable, entertaining, unique, or informative, and that they should be designed by considering aesthetic factors.
How far do you take quality?
Not very far.
I mean, if Amazon said we're not going to sell any goods in the EU without a CE mark, you wouldn't necessarily say that they were using the sign, would you?
Not necessarily, but it's true also that Amazon, the quality of goods, you take your chances with what you order. I mean, it's that's not the case in this environment. This is very much a controlled environment, we say. So we don't push the boundary on that too far, I hope. So I think that's probably all of the factors. But I mean, for what it is worth, at 107, she talks about how the judge talks about how the affixing, as we call it, takes place effectively arranged by Samsung, of course, through syncing the phone with the watch and accessing the app store and whatever it is. And
Well, there seem to be a number of different points there, and I'm not sure they're all relevant now. So first is the question of in the course of trade. That's not an issue anymore, so we can forget about that. And then there's the question of the precise form of use, but is that something we need to worry about? Because as she rightly points out, the directive and for good measure the UK 1994 Act, it's an inclusive definition.
non-exhaustive, and in fact, in the Google France case, the Grand Chamber says, drawn up before the full emergence of e-commerce. So, you know, intended to be a little bit flexible, and the manner of use can change depending on the case. Incidentally, for answer to my Lord Justice Lewison's point, this seems to be the paragraph that I had in mind. Samsung would also field customer complaints about them and provide a level of customer support. That I think is the paragraph that I was looking for earlier. So we say those factors are good. They range from being highly relevant to fairly relevant, and all of them together are a multifactorial evaluation, and that the challenge here is really to that multifactorial evaluation, and it's we say misplaced. The basic point about Samsung's own substituted factors has already been made, which is, if anything, the factor of contractual prohibitions between from Samsung to the app developers to prevent these illegal content coming into the store. That's even less known, but to the extent that is relevant, we say that's wrapped up in a lot of the judge's factors anyway, not on quality and so on. So just, I mentioned that we had a respondent's notice on this point, and this is the point about, and this in a sense is a very direct application of own commercial communication. The first point is we're actually a little bit unsure about whether we need a respondent's notice for the point the point put to me earlier. But I'll show you what it is just so that you can see. It is the last page of the bundle, the core bundle, and it's the first paragraph. So the page is core 254, tab 8.
Yeah, well, you've anticipated the question I was about to ask, which is to what extent the judge focused on presentation, which, as discussed previously, is key.
Yeah.
So, yeah.
So let me show you why we potentially don't need the because the basic thing is that the judge did deal with this factually, and we know that because of a number of parts of the judgment. They weren't all necessary. They didn't all coalesce around these particular paragraphs that we were looking at, but it's quite clear that the judge's view and the specific finding was that the app seller name, contrary to what was submitted yesterday, was either not present for a substantial number of consumers, or if it was present, would not be understood as an app seller name. If I can take you to the first paragraph, is the judgment at paragraph 24, where she is dealing with the Samsung evidence and Mr. Kim. He's a senior professional at Samsung whose role includes managing the app review process and the overseas training, background in electronic engineer. His evidence about Samsung's approach to content review, and in particular the IP assets, was helpful and informative. His evidence also made it clear that the apps in dispute would have been rejected if sorry, yes, it's 25. Mr. Kim's evidence about Samsung's approach to content review, and in particular the sorry, I've got completely confused. It's actually Mr. Lee, 27. Mr. Lee's evidence in cross-examination was in some respects a little less straightforward.
You're now at 27.
So 27, I apologise, my lord, yes. He did candidly accept that a smartwatch is a watch, but maintained his written evidence that the difference between an analogue watch and a watch face app was easily perceived. He also suggested that it was rare for an always-on feature to show a brand name, despite a substantial proportion of the apps in dispute doing so. I'll come back to that on ground two. But it's this part. As discussed below, I also had some difficulty with his evidence, which I consider in any event to be an expression of opinion, that most consumers would identify that the apps were sold by third parties before deciding to download them. So that's the first passage. But then if you turn forward to 71, the judgment, and this is again a sort of background section, and accessing apps from the SGA store. And there are two subheadings: access from a smartwatch and access from a smartphone. And it's necessary to have a look at the supplemental bundle, please.
Well, just before we do that, I'm keen to have a look at that. But do I understand the point you're making is what the judge says in 72, about halfway through the paragraph? No information about the seller of the app is provided at any stage of the process just described.
That's it. So it's not just some or it's illegible. There's just no, you can install from the smartwatch without ever being exposed to a seller name. Now, I'll show you just a picture of that. That's all I wanted to show you. It's
Well, there are 2 points there, aren't there? One is that you don't know about the seller, and the other is that Samsung's own apps and third-party apps are mixed up together.
yes, they're mixed up in this sense that the one scrolled through first of all Samsung, and then one hit the third-party one with no distinction, and you simply.
Going to show us a picture?
Yes. So if you look at supplemental bundle tab 1, and if you turn please to pages 4 and 5. So you've just got your watch, and you click on the anywhere on the face, I think, or any of the buttons. You get the legal terms; those are on 4. Incidentally, they all said all content is made available to you by the Samsung Galaxy store. But anyway, you agree those terms, and then you come to the little roundel of coloured icons on sub 5, and then the picture of the shopping bag is the SGA, and you click that, and you've got a sort of scrollable vertically number of things, and watch faces is there. And then you are presented with watch faces, and you've got a little preview there. You can see the edition, special edition rows on 7, and you've got the AE Aeronaut on 8, and then 9, the Tissot. And I should just say this, the Aeronaut one is there because that's got an install button. So you can press that and install from that screen without being exposed to the seller name, as the judge held. The picture of the Tissot one, the reason why that doesn't have an install button is explained in a footnote of that part of the judgment, that an earlier version didn't have that, but so far as concerns some of the infringing period, you could install directly from that screen. Of course, that watch is no longer available, so it isn't something that we can look
Sorry,
at now.
I'm not sure it particularly matters, but can I just check I've understood what you just said correctly?
Yes.
Do I understand, therefore, that in the case of the TISO, for some of the time you could install it directly from the smartwatch,
Yes.
at other times
From that screen. Yeah.
you could not?
Oh no, you could always install directly from the smartwatch, and still can.
Right.
But it's the question of what information you got when you saw the when you did that.
Directly from this display.
So exactly. So now, at the time when you clicked on TISO Watch, you got a name, and a bit like I think it's not the next one, is it? It could be. Is it page 11? It's 11. So you clicked on that, and then you got installer, installer, because I think that was the French SJE.
Right.
And then you got German Gomez underneath. You see that? And so you did get what Samsung will say is a seller name then. Query whether you knew exactly what that meant or who that person was, if indeed it was a person. But it was certainly the case, and it is no point was taken by Samsung, as the judgment records, that this wasn't so that the version without seller name was online and available for a period of the infringing, for some of the infringing period.
So do you get from the picture at page 9 of the TISO face, the picture at 11 by doing something on the smartwatch?
Just one moment.
So that you get the install button?
Yes, if you clicked on that, then you get to page 11, and you will
So
see.
you click on the image on page 9,
Yes.
and that takes you to page 11.
Yes, and of course, I mean, that was in one version of the software. Another version was sub 8, where you clicked on install directly from that page.
Yeah.
That's it. So,
And can you just help us on this? I'm looking at page 11. You've made the point about German Gomez, and one sees in the context section of the table, the bottom entry says, the screen does not say the seller is German Gomez. Consumers might perceive German Gomez as the designer of the app, and then there's a transcript reference. Could you just help us? What is the transcript reference there?
I should have checked that, but I don't immediately.
I'm assuming that's a witness's evidence.
Yes, but I can't remember which one it was. But it's, I mean, it says what it says, which is German Gomez. And I think the point there is that, I mean, this might be even a submission rather than a witness, rather.
Right. But do I understand that this is an appendix to your closing
It
submissions
is,
at
yes,
trial?
yes.
Right. Thank you.
We can check that, but on my feet, I'm not able to assist at the moment. But we say that that's obviously quite, at least ambiguous, that the seller is Samsung, and probably the most likely scenarios that is that you do think that it's Samsung in both cases. Now, the judge then dealt with the downloads from the smartphone. So that's at 73, access from the smartphone. And again, the details, actually, if you still have 3 supplemental, you'll see there's, I think, a picture of that as well. I think there's only one picture of that. That's on supplemental 15, TISO watch face.
That's 13, is it?
Supplemental 15.
We start at 13, presumably.
We do start at 13, yes. I just thought that the pictures of the watch faces are perhaps in their fullest glory in 15. So that's what that looks like. And what the judge said of that was, whilst there was more information, it's fair to say that because more than one app can be previewed at once on the phone, the variety of different names and the fact that on some of them Samsung's own name might appear instead of a third party, that does more to flag up that the name may relate to the source of the app. So there's a distinction between the two scenarios. But we say, and that's one of the reasons why we highlight the smartphone downloads. But we say it's not necessary. Oh, the cross-examination that my Lord Justice Arnold was asking about was Mr. Lee,
Right.
Samsung. So really we say when it comes to the first ground, respondent's notice should hardly be necessary because of the judge's specific findings. But if it is, we obviously rely on it. We say for a substantial proportion of consumers, the use was in Samsung's own commercial communication for the reasons given by the judge. And
So
the
the
criticisms of-
respondent's notice also references paragraph 154. Does that assist on this or not?
It does, because that's a section where the judge is dealing with use, but in a different aspect of use, functionality and so on. Function and descriptive use is that section for judgment at 147. And in 154, the fact that the third-party developer's name appeared in the app details is insufficient to displace that assumption, the assumption being that they are they come from the official Samsung site and that there is question of what goods and services is this section. Now, the fact that the app developer's name appeared in the app details is insufficient. That name was neither necessarily seen before the app was downloaded, and she refers to paragraph 72, which is the one we were just looking at, nor was it made clear who the person named was intended to be. In particular, it was not made clear that the person named was the app seller, rather than, say, a designer or design house. I also find that a significant proportion of average consumers would view and download watch faces apps directly from the smartwatch, being the obvious place to view them and determine what app and apps they wish to acquire. And they would be unlikely to see the developer's name or to appreciate its significance if they did. If they focused on a name at all, they would have been more likely to focus on the name of the app. So yes, that's that paragraph, although it's in a sort of different section dealing with descriptive use and function, it's clearly a finding that is difficult for the friend to dislodge. So we say in relation to the first ground, the appeal should fail. In relation to the second ground, my learned friend was relatively brief on that point, and I hope I can be as well. There was a discussion about informational products, what are sometimes called image carriers in this branch of the law. And my learned friend is quite right, of course, to raise some of the difficult and interesting questions that arise in this part of the law about arsenal scarves and whether they are badges of allegiance or badges of origin. Does it matter whether there's a disclaimer at the point of sale or it's given by somebody as a gift who doesn't know about the disclaimer? But essentially, this is an acutely fact-sensitive question, and here there are clear findings of fact against my learned friend. So the first point is use in relation to smartwatches. Is that use, at least as the judge held, away from the point of sale in the post-sale context? Now, the Samsung second ground of appeal contends, in essence, the judge should not have held that there was use of the signs in relation to smartwatches at all. But I didn't detect my learned friend's challenge in answer to a question from Lord Justice Arnold, the proposition that in principle post-sale context was relevant context. Indeed, it seems that Samsung say that the judge was correct to hold that there is a post-sale context in a theoretical case, but in this case, the factual assertion was essentially that it won't happen. It's factually, the chances of it happening are factually so slight that the court could disregard it. It was said by reference to Celine and some other cases that the link had to be made between consumers and the products in question. So the link had to be made by consumers between mark and goods, but that had to be in a realistic scenario, which of course we don't disagree with. But my learned friend goes on to say there was no realistic scenario was here. it was said that either the phone was off, or it was dimmed so much that the brand name was not showing, or even if the watch face was on, third-party consumers would know that the use was in relation to an app, because they just know that type of thing. Now, my learned friend's first difficulty is the obvious one, repeated in various places by the judge, that these particular products, watch faces, are very slightly unique type of product. It goes to the point I made earlier about their propensity to designate origin and to be assimilated to the watch itself and to be considered to be part of the watch. So that's a problem, because if there was any chance of exposure to other people in a third-party context, and other people in this context means consumers, because these are just goods sold to the ordinary public. We're talking about the Swatch brand, or the Tissot brand, and going up the chain, potentially Longines, Tissot and Omega, all the way up to Breguet and other brands. It's still the general public, and we say there was a real risk that when viewed in the post-sale context, they would be taken as indicating the origin of the goods.
But what strikes me as slightly odd, and there's no doubt a good reason for it, is that before download, the judge finds that the use is in relation to an app.
Yes.
But after download, it's used as use in relation to a watch. Now, that's not like buying your T-shirt from Victoria's Secret with pink all over it. It's the same thing.
It's the same use.
In the shop and outside the shop.
Yeah.
Whereas here, it changes.
It does.
And the reason it changes is because the consumer decides to download that particular watch face.
Yes. So the consumer has downloaded, they bought the product, to use general language. So they bought the T-shirt, so to speak, and they've walked out of the store, notionally. And the question is, what is the effect of the exposure of that sign on others? We say nothing wrong in principle, and there's nothing wrong in principle between those two findings. It is possible that could happen. It is unusual that a use could change. We have a respondent's notice in relation to that, because we submitted that when the app is shown in preview on the store, whether either on the smartwatch as you've seen or on the phone, it's telling you this is going onto your watch. This is what your watch is going to look like, and it's going to have Tissot on it. And therefore, it's a sort of advertising use in relation to the goods, so to speak. It's not in relation to an app. I mean, obviously it is in relation to an app, but its functional, its object and effect, or its functional use is to act as a sort of badge of origin in relation to the watches. So, but we don't really need to go that far, we say. We do have the respondent's notice, but we say it is potentially open to the judge to have held no, strictly speaking, in relation to the use at the App Store. The use is in relation to one thing, and in the post-sale context, another. And that's really because the post-sale context can be a bit of a game changer in many respects, both in terms of confusion, who the average consumer is, as in London Taxi, or in this respect.
And you say that that's still used by Samsung?
Yes. Yes.
So do I understand from that your submission is there's an analogy can be drawn with the label inside the packaging? So you buy goods online, and at the stage where you buy them online, you're not misled. The parcel arrives at your door, you open the package, and there's a label there, which purports to tell you the trade origin of the goods, and does so falsely.
The very example.
Which is the analogy given, the example given in data card.
Yes, exactly. It is, one has to be careful with analogies. I mean, the pottery example as well. I mean, but one can think of many cases where there are signs that are either not visible at some stage and then they become visible later. Is it on corks of wine?
Yes,
is the one that springs to mind.
Yes.
I think there's a long practice of having trademarks on the corks inside bottles. So we say there's nothing particularly difficult about that, unless my learned friend is challenging the legal proposition. is in difficulty because there are clear findings of fact. But for what it is worth, I should deal with the always on display, always dimmed, and so on. Now, in relation to that, it's important to bear in mind what we're talking about. So the watch will dim to black, like a smartphone. That's not always on display. That's obviously just normal display. It'll go off.
So there's an ordinary timeout feature.
Timeout feature.
And the judge says the default was 15 seconds.
Yes, exactly so.
The
A
user
judge
could presumably set that to be 5 or 30 seconds or whatever.
Yes, I think it could be up to 5 minutes, but depending on how long you wanted to show it off to your friends having bought it. But yes, the default was 15 seconds, which is quite a long time actually, for the face to be in full glory.
Is there a finding by the judge of up to 5 minutes?
No, that was the evidence at trial. It was 15 seconds at paragraph 40. We said that was long enough. And then the always-on display was the sort of simplified, pared-down version. I think you looked at those pictures yesterday, and I inadvertently read you a passage from the evidence, Mr. Kim, where that, Mr. Lee's evidence, where that point was controversial. The judge didn't think that the witness was entirely accurate when it came to describing the the prevalence of trademarks shown in the always-on feature. I don't know if my lords and lady wanted to have a look at those pictures again. It'll just take a second. But there are a number. It's supplemental bundle tab 2.
The judge deals with this, doesn't she, at 165?
Yes, she does. And yes, the watch face app would obviously be shown when checking the time, whether for the benefit of the smartwatch owner, for the benefit of anyone else. Given it provides the interface, it would be the screen first seen when lifting the arm or flicking the wrist. And other people would like to show others. I mean, we do very much take those points from the judgment. But specifically on the always-on feature, it was suggested that you couldn't see the brand. I mean, I would suggest to the contrary. You can see the brand in most of these.
Well, just before we look at the exhibits, you drew attention to what she'd said about the witness's evidence, but
yes.
Does she not say something about this substantively?
Let me just see. Yes, is it 46? No, this is a different point I also wanted to make, but I believe she does refer to this in several places of the judgment.
I thought it was 165, which was the key paragraph on this point.
I'm sorry?
I thought 165 was the key paragraph on this point. But
Yes,
there may be others.
my lord's absolutely right in terms of the consumer. This is the realisticness of whether this would be exposed. Absolutely, I do rely on that. But specifically on if it was in always on display or black, with timed out, always on display sits there all the time. Right. It doesn't go off to black in 15 seconds. So the only point I was going to make about these is the quality of the photographs is poor generally. Do not assume that where it shows the brand you can't read it. So for example, in 21, where you've got the swatch version, that the word swatch is pretty indistinct on the original face as well as on the always on display, and it's just most of these have the brand in the always on display. That seems to be a feature that is more often kept than not, but certainly anyway kept in a very...
Sorry, I'm not sure I've understood correctly what you just said. So you said something about quality of photograph.
Yes, yes.
And I take the health warning, but taking page 21 by way of example, the left-hand one, which is the preview, is nice and sharp, and therefore swatches, at least in this copy, plainly visible.
Yes.
Whereas in the right-hand one, it's blurred and it's not visible. Now, Mr. Alexander told us that that was because of the feature of the reduction in the number of pixels to 15%.
No. You can tell that by the bezel. The photograph itself is blurred.
So you're saying it's a blurred photograph?
Yeah, this photograph is a poor quality photograph generally. I mean, you can see that from the bezel of the actual watch and compare that to the one on the left. That particular example, I'm not saying they're all like that, but if you look at 18, you can see potentially another one where the picture is just not very clear. 19 might be said to be the same. This was not. It's not the case that you couldn't read the trademark. The trademark was there, and
How do we know just looking at this? I mean, that's why I was interested in what
Yes.
the judge might have said about this.
yes, quite right.
I don't think we can resolve this
I don't think we
disagreement
can
between
without
you.
going to the cross-examination, and I don't think boards want to do that. So I will move on.
All right, but where we get to on this is you don't accept factually that the trademarks were not legible
Correct. And that meant always on.
in the always on.
Yeah.
Is that always the case, or do you say that there's a differential? Sometimes legible, sometimes not.
If absent, not legible, but where it was there, it was legible. We don't have much record of this anymore, of course, because they were taken down, and Samsung produced those photos, I think, during the trial.
I think in a way, more to the point from our perspective, there are no findings about this, are there?
Yes, that's true. But what the judge did say is that when she criticised the witness's evidence, she said, well, it wasn't always forthcoming about there being trademarks on a number of them. I think that we can go that far, but no further. Yeah. The only other fact that we would say is potentially relevant as well is if you look at 46 and 47 of the judgment, there are findings about the prevalence of downloading and the lifespan of these products. And we say that's relevant. So let you find those passages first. 46, 47.
Well,
Yeah.
just before we go on to that, I was going back to paragraph 27 in the judgment, which I think is the only finding on the point to the extent that there is a finding, and it's what you referred to as before.
Yes.
Discussing Mr. Lee's evidence, he suggested it was rare for the always-on feature to show a brand name.
Yes.
And then the judge says, despite a substantial proportion of the apps in dispute doing so, a fact he accepted.
Yes.
So that seems to be a finding, a broad brush finding.
Yeah.
A substantial proportion of the apps do show the brand name, whereas others do not.
That's it. And the judge had those exhibits, so there was nothing more legible than that. So I'm not sure I can help much further on the legibility, but in terms of the presence of the brand name and showing the brand name, that's it. 40. So the next point I wanted to make is that really answers my learned friend's point about, oh well, sometimes people might download this for a bit of fun and then off it goes, and they'll download another app and another app and another face, and who knows. But in fact, there was evidence as to how many apps watch face apps people download, and how long they will have stayed on board for. You can infer that from the last sentence or two of 46. So actually a relatively small number of smartwatch users made active use of the SGA, which is an important point. in terms of sort of what mindset point, 26%. But with those who did, downloading an average of only 4.6 watch face apps each, 4.6. And if you look in the next paragraph, Samsung watches are generally in use for a relatively short period. The average replacement cycle is about 27 months. Now, obviously, no one's an average, right? But on average, 4.6 watch face apps during the lifespan of the product is a very low number. And therefore, we say, once they found a Tissot or a Jacquet Dro or whatever, yes, they might have discarded it, but equally, it might well have stayed on for quite some considerable period of time. Now, I mentioned the respondent's notice. Really, I think I've already submitted what we would say in relation to that. The judge could have, and we say potentially should have, found that the preview mode on the phone and on the watch was also a use in relation to smartwatches. So in other words, I think that's the second ground. So far as the third ground is concerned, there are a number of points, and I'll be potentially guided by laws as to which of them I should develop. But it may be helpful to start again with the judgment on this. We say that at its heart, the judgment was a fairly simple and straightforward finding that by looking, which they had no obligation to do, Samsung looked and opened themselves up to problems with this defense, because by looking they learned of the content of the information. And that's the big dividing line between liability and non-liability in the e-commerce directive cases. And to take a very simple example, the BT lines that were carrying the data that contained the watch faces from the Samsung servers or whatever onto the user's smartwatch. They didn't know, BT didn't know anything about the information. They didn't know anything about the content. They weren't given any notice or notice and takedown, and they were not liable, and they didn't have any, they would have a complete defense. But as soon as you step out of that guise, then you make yourself aware of the information. For whatever reason, there's a problem. Now, my learned friend almost correctly presented our, portrayed our position when he said that Swatch are suggesting that they should do nothing, they should not look. It's not that we say that, but we say they can choose not to look if they want to. We're actually agnostic as to whether they do or don't. It's a matter for them. They should, as a responsible provider, do something, but it's not for us to say. They have the choice under the e-commerce directive of essentially doing nothing like a BT and not apprising themselves of the content of the information. But if they do, then they can't pretend they don't know anything. And if they do, we say, as a...
So, sorry to interrupt you, just so as I'm clear as to what you're saying. I mean, the example of BT is not apposite, because that's a separate safe harbor under the e-commerce directive.
Yes.
That's the mere conduit.
Mere conduit, and then there's mere caching for the servers.
Right, okay, so, and we're not concerned here with mere conduit, we're not concerned with caching, we're concerned about storage. And the case law tells us that storage has to be quite generously understood in this context.
Yes. And we can see that.
But do I understand that your argument involves parity of reasoning, which is to say, if you confine yourself to storage, generously understood, and you are passive, to use one of the expressions in the case law, then you're immune from liability. But once you go beyond that, you're potentially exposed. Is that
That's
what you're
it.
saying?
That's exactly what I'm saying, and we know that because recital 42, and I'll take you to that, says it only mentions the caching and conduit exceptions, and it specifically introduces the point about technical, automatic, passive. I'll take you to it, it'll make more sense when I do. But that was the first basis on which you lost the immunity. And then the later case law, as I'll take you to, introduced the diligent operator standard.
So if I'm operating an online marketplace and there are third-party sellers, as soon as I look at the packaging, I may be liable because I can see that it's a packaging of some famous brand.
You might be. You might be. I mean, it's
Quite
very
far-reaching.
fact sensitive.
That's quite far-reaching.
Well, it's
isn't
very
it?
fact sensitive because it depends who you are. So the other facts that we need to plug into this case are: this is a company selling watches, not smartwatches. There's been findings. This is a watch, and if it's a smartwatch, it's a subcategory of watches. It does the same thing. It sits on the wrist, and so on. So this is a company that should know what it's looking at. It can't approach it as if it's some unknown Martian object. This is a watch. One looked at the content review guide, and Omega wasn't there. Rolex wasn't there. IKEA was there. A number of computer games manufacturers were there. Now, this might have been part of the conviction of the Samsung company that it simply was not selling watches, it was selling computers. But the reality is that this is a company that markets its products as a watch, as a real watch, as a watch-looking watch. And therefore, when it looked at that information, should have been alive to the possibility of infringement. So it wasn't. I think you.
Suppose that's right. You said awareness of the content of the information, and suppose that they say, well, that may be an infringement. Is that enough, or have they got to go out and find out whether it was an infringement, whether it's been licensed by Tissot or whoever it is?
My lord asked yesterday whether they need to build upon
Yes.
information. We say they don't need to build upon. They need the foundational knowledge at the outset to do the job properly if they're going to look. So they need to know. Nobody is suggesting that they need to understand whether the mark is liable to be revoked on grounds of non-use, or whether there's a defense of freedom of expression, or whatever it might be. They simply need to identify there is to take a brand not from this case, Breitling watch, and there it is. Breitling don't do smartwatches. They don't. They know this. They know that none. There was evidence in the case from Mr. Dollar that none of the Swatch companies had ever licensed smartwatches or been involved in the smartwatch world, and in fact had rebuffed advances from the smartwatch companies, unknown. They will know that they ought to, as foundational knowledge, ought to have known the main watch brands. We were talking about the second, fourth, and fifth biggest watch brands in the world amongst the stable that have been put forward. So it was no defence to say that they hadn't heard of some of the more upmarket ones.
If my ignorance, can you tell me which is which?
I believe it is
Second.
Omega, Tissot, and Swatch. Yeah, I think Longines might not be far behind.
So Tissot is second.
Is Tissot second or fourth? Fourth. Yeah. So Swatch is Omega is second, and Swatch is fifth or fourth. Perhaps I'll take instructions rather than.
I'm glad to hear it's not just me that's ignorant.
Yes. I mean, it may be that some of these brands the court has never heard of at all, and that's fair enough.
Difference
But we're not.
between hearing of a brand and knowing which is the big.
But the difficulty for Samsung, we say, is that because they hadn't dealt with, they hadn't weeded out Omega or Swatch, it didn't really lie in their mouths to say, well, we hadn't heard of Jacques Dreux, and how can you expect us to have heard of them? For what it is worth, there are two factual findings on this particular point by the judge, where she holds, in relation to both witnesses in cross-examination, both of them accepting that had they known about these
Yes.
brands, they would have not let them through.
Yeah.
So it wasn't a matter of having to know the trademark or considering the licensing position. They just wouldn't have let them through. And it's a fairly robust, it's a tough world, the notice and takedown world. People send a trademark in and an example of the product listing, and Samsung take it down. You know, and there isn't an inquiry of the sort of fine-grained nature that.
Well, my Lord Justice Lewison and I will be tangling with that next week, because of course it gives rise to the problem of threats.
Yes.
So we are alive to that issue, but what relevance does that have?
The relevance is really the point that we were trying to say in response to some of the points made yesterday about having to leave your seat and look in a trademarks database. I mean, incidentally, TMView, which is a website which contains all of the trademarks in all the countries of the world for free, can be checked in a matter of seconds. And indeed, the witness confirmed that they had voluntarily done that since the litigation had started. Some of these things are not difficult, although we're not requiring them to do them, actually.
Yeah. You've drawn attention to the answers that were given in evidence, which the judge accepted, that if Samsung had known about these brands, they wouldn't have allowed
Yes.
the act. Now, inherent in that, of course, is that they didn't know.
Yes, that's right. And
So you accept, I think, that they didn't have any actual knowledge or actual awareness of illegality.
correct. We do accept that. It's Lim 2. There is something else. There's a normative standard that comes in under Lim 2, and I'll show you that in the case law. We say that the position is quite simple. If you actually know your imputed knowledge, as it was said, that's fine. You get that. It didn't concern us as to whether they were telling the truth or not on that. It sufficed for us to accept that they didn't know. But that's a question, as the judge pointed out, principally of sort of training and setup. If you are going to operate a content review process involving up to 6 minutes or around 6 minutes, they were instructed to look for between 6 and 10 minutes, I think, and 5 and 10. And they, on average, looked at for 6 minutes at each app, screenshots. So they weren't looking at the functionality. This was separate. And if you're instructed to do that and you're looking at it, then the people who are doing that for the whole world need to have some basic knowledge about competitor brands, people likely to complain. It seems to have been the approach, actually. It was a list of people who were likely to complain in American sports clubs and football teams and McDonald's and IKEA and so on.
So does it come to this, that you can choose to do a content review or you can choose not to?
Yes.
And if you choose not to, that's the end of it. But if you choose to do it, you must do it properly.
You must do it properly, and we say that obviously the preferable course is to do it and do it properly for everybody, for Samsung and for the rights holders. But you can, if you want, take a very passive approach. The downside of that, and the reason why they don't, or they either try and leave it to machines to do it or do it in an inadequate way, is because, of course, they don't want, that means all the content goes up onto their store for a while until there's a notice and takedown. So the problem is it does degrade the quality of the store. So if you're trying to maintain, as Samsung were, a very nice quality app store, you want to have some content review as well as the functional review. But of course, that's got to be done properly. It's got to be done properly. Otherwise, you're dealing with a situation where intellectual property is being looked at as a specific topic, but not for the people that matter. I don't know if you've had a look at the content review guide, and it may be just worthwhile looking at a couple of pages.
Yes, I think we looked at it a bit yesterday.
So the startling thing is, so it's supplemental tab 3. There are, of course, lots of pages about culturally sensitive matters such as gaming and sex and nudity and so on. But there is a section on intellectual properties the judge noted, and it does mix up brands and copyright and so on, but that's to be expected sometimes. Page 66 of tab 3. But some of the mandates in this review guide are of general application. They're not simply related to Samsung. So we start with you must not copy existing apps, and then we go straight into the Samsung brand. There's quite a lot of detailed guidance on the Samsung brand, which implies that we didn't really. The man who attended for cross-examination was the head of the group, so we didn't have the sort of average reviewer able to help us with the degree to which they understood some of this guidance. But one assumes that, because it was said that there was training and so on, one assumes that they were given training about licensing and that sort of thing. And there's some quite detailed guidance about licensing of the Samsung Electronics
How is a reviewer
brand.
supposed to implement 3.2.6? If that includes free or open source software, it must comply with applicable open source software license terms. How are they supposed to do that?
I'm not sure I could comply with that. I don't know where you find those terms, but presumably they Google it or something.
If it's open source, there are a variety of different open source terms
Yeah.
and conditions which are publicly available, so that's the whole point of them.
Yeah.
But checking compliance is not necessarily terribly straightforward.
I mean, to be clear, we're not saying they should have done that necessarily. And in fact, we rely, as I put it before, on sort of foundational knowledge, basic knowledge of brands, likely brands that will be coming across from the developers. Now, I wanted to show you so there's actually some pictures showing different uses of Samsung. If you look at 69 and 70, you've got sort of descriptive uses and pass and fail in their second column. That one in the baseball picture of the baseball game, you've got Galaxy in the background. That's a pass, and then this image, the one below that, is a fail. I can see the power. Oh, it must be in the red box. Basically, this application should be failed because it uses powered by Samsung. The seller must submit the evidential document with the brand committee. So there has to be a request for information. Then we've got football clubs worldwide, cartoon characters, and a list of the great and the good in the field of trademarks. But like Chanel make watches, so I suppose Chanel might get there. But it's a bit, it sticks in the throat that you see IKEA there, but not Omega. I mean, IKEA people aren't likely to be producing IKEA watches, but the point is that they were approaching, this was not just a technical review, this was not just a content review, it was a content review about intellectual property for what it's worth, and there is a lot in the ensuing pages about video games. So they were alive to competitive products, of course, those Android.
Can I just ask you this question, and it may not matter either way, but one thing that's slightly puzzling, given the point you've just made, is if you look at page 70, 3.2.3, and then it's the headings in the table, and in the middle of the page it says example famous trademarks.
Yes.
So, do we understand that these are examples of what reviewers are supposed to be looking for?
Yes.
Rather than a closed list?
I think this is an example because one of the judge noted that one of the witnesses was aware of some of the sports club. Brad's was a sporting enthusiast, and it might be that that these football clubs are very popular in Vietnam, where these reviewers were based. But I don't know how. I mean, this went through. The other thing about this content review guide is it went through a number of versions. It wasn't just something that was evolved and then devised and then just left on a shelf gathering dust. This was updated, presumably, when if anyone ever complained that they got included. But I think there was evidence that was a sports.
Sorry to interrupt you, but just can I pursue my question? Because
I think so.
what I'm asking is whether there's any evidence about this. So let me just focus it so as with a non-contentious example.
Yes.
If you look at football clubs, we've got people like Manchester United, Manchester City, and so on. But to take another prominent football club, Paris Saint-Germain is not there. Now, so do we understand that if it's Paris Saint-Germain, then that's unobjectionable, or is that equally objectionable because it's of another species of the same genus?
It's another species of the same genus. It does say
Was there any evidence about that?
The only evidence that I can think of is it's 59 of the judgment, last sentence. Last two sentences. Sports-related advertising. I think that sort of
59, do you say?
59 of the judgment. Yes. It's talking about Mr. Lay's team comprising 14 individuals. At the last sentence, he says, Mr. Lay's own knowledge of famous watch brands at the time appears to have been limited to what he picked from sports-related. So he was a sports enthusiast.
Okay, but is not 68 rather more germane to my question? Because I think this tells us how the judge interpreted it.
Yes. Sports clubs, cartoon characters.
It says table of screenshots providing examples.
Yes.
And then it says it provides pictorial examples of a number of well-known sports clubs, cartoon characters.
Well, quite. In general, we say that it is examples. Yes. 69, as I'm reminded of the paragraph of the judgment, it can be seen from this that there was no clear instruction to do an internet search of any kind, at least in respect of what the viewer did not regard as well-known contents, and certainly no instruction to check trademark database. So they were relying on the knowledge of people, and so when they were using examples, I think it probably was just that. There may be others. I mean, I think maybe the Paris Saint-Germain team wasn't doing that well at this stage, as well as they are now, since they've been bought.
Suppose that a company like Samsung said, well, we're going to do a content review, and what we will look out for are explicit sex images, things that are illegal, but we're not going to check anything to do with IPR.
That would be better in a sense, but I think they would still fall foul of the knowledge and control of the information because it's coming out of the technical and automatic and passive. This knowledge exists along a spectrum. There would be a purely technical review, and in fact, we looked at Peterson yesterday where there was indexing and automatic searching and even offering of YouTube content in response to consumer preferences by a machine. That's not knowledge of the content. It's still not really knowing what the content is. This was perhaps further along the scale. There would be the sort of thing that Milord just postulated, which is knowledge of content, but not with IP spectacles. And it might be that there is some basis for that, but I would suggest that that's probably on the wrong side of the line, because you then bring to the table what you know about the content. So if you know that, for example, it contains something defamatory because for whatever reason, or you know that that's a breach of Coca-Cola's trademarks, even though you're not looking for it, then you get and the Peterson court says that, you get into trouble. You become aware of facts giving rise to apparent illegality. So certainly with this case, which is further along the scale again, when you're reviewing with intellectual property spectacles on, you do open yourself up to the charge that you have gained awareness.
In that answer, you covered, I think, two different subjects, which might be worth trying to disentangle. So, one is the distinction between automated processing, and you gave Content ID on YouTube as an example of that, as distinct from human review.
Yes.
And here we are plainly in the field of human review. This is not simply automated processing.
Yes.
And your submission is that once you move away from automated processing, then you are at risk. I get that point. But then there was a separate point, which is you used, I think your expression was, you bring to the table your own knowledge as a reviewer. Now, how far does that go? And let me be specific to our context. So, we have in the field of trademark law the concept of well-known trademarks. And certainly people like McDonald's would certainly claim to be well-known trademarks in many countries of the world. And indeed, I think the content review guide is rather proceeding on that basis. Now, is it your submission, therefore, that people who do engage in human review of this kind are deemed to know about well-known trademarks? And if not, what is your submission?
Yes, that would be my submission, but I would go further. The points that you raised, my lord, in relation to human versus machine need, first of all, some thinking about. There are machines that could cloak you with knowledge if you design them appropriately to review content. So, for example, there are already existing filters and so on that can detect copyright infringing work. And it might be said that, I don't know, I'm not saying this is it's been held, but it might be said that even in those circumstances, the machine is effectively cloaking the company or cloaking the company with knowledge. But let's leave that aside. We are dealing with a human review case. Where there is a human review, then yes, we say as part of the diligent operator standard, you must be dealing with what I've called foundational knowledge that you bring to the table. If you are a car company, you should be aware of the practices of the industry generally. You don't have to be an expert, but you just have to be, you would be taken to be objectively to bear the characteristics of somebody in that sector.
Just pause a minute. You said that as part of the diligent operator standard, you must bring that you must be dealing with foundational knowledge that you bring to the table.
Yes.
You changed that slightly. It's the foundational knowledge that you should have brought to the table.
Should have brought, yes, exactly. Sorry, yes, exactly. Because I'm allowed to say should. I don't have to have, and indeed in this case didn't have the knowledge according to Samsung. So we say something like that the knowledge that you should have had as a sort of reasonable operator within that industry. So you're not required, if you are Samsung, to know all the obscure Dutch furniture brands or whatever it might be, or you're not required to know all the pharmaceutical brands, but you ought to know the second, fourth and fifth watch brands, which brings me to the point raised by Lord Justice Arnold. On that, we say, clearly you should know the well-known brands in your sector. Whether they qualify as well-known marks, probably they will, because it isn't clear, certainly my understanding of the law, that well-known mark standard is something only for household name brands, but as always, it's a substantial proportion taking into account and so on. But it might be that some fall short, and they still need to be known by the diligent operator. but certainly the ones that would qualify as well-known marks. Just the finding of the judge at 175 on this is also pertinent. Marks such as those associated with Omega, Longines, Tissot and Swatch are very well known. Their reputation is obvious. And that's not just to a diligent operator in the watch, of a watch marketplace, or watch app marketplace. This is to anybody.
So is it your submission that that is a finding that Samsung must have known that because the reputation is obvious?
It's obvious. Yep, it is. And if they didn't, then they should have. I hesitate to, I must add, because I didn't challenge the truthfulness of the witnesses, and in fact, one can very easily see how they didn't know if they didn't, because there was a small number of people in Vietnam. They were soft.
Is the question whether the individual reviewer knows, or is it
The company.
whether the company knows?
It should be the company, and the company is the one that's responsible. They're the subject to the should obligation. They are the ones who should be training the people to have a basic level of knowledge so that they can recognise an obvious infringement on a double identity basis. I mean, this was the other point. Yes, there might be some in the schedule of infringements annexed to the judgment. There might be some fine-grained decisions to be made between Omega, or OMG and Omega and so on, but there were a large number of double identity cases, lots of double identity, quite clear. And of course, don't forget, this wasn't just the trade, of course this was a trademark case, but it was a case in which the contextual use of the trademark was identical mark on identical face. So, you know, the iconic faces such as the Breguet face or the Omega Seamaster face and so on. So these were, these added to the likelihood of them being spotted if there had been some basic level of training, basic level of knowledge on the part of those doing the review. Yes. That's right. On training, I'm jumping around a little bit, but on the training, there are, of course, near the end of the judgment, where the judge is dealing with the honest defence, a number of points. My learned friend takes issue with these and says, well, these are all points where the judge was holding us to a sort of a standard that she shouldn't have held us to.
Well, he also says it amounts to the court micromanaging.
Micromanaging, and we've left the moorings of the directive. This isn't micromanaging because the judge was not saying you have to do this. What she was saying was this wasn't done, and this falls below the diligent operator standard. And we know that because when it came time for the consequentials hearing, and Samsung tried to say, well, we're doing it now, don't grant an injunction, the judge said that they misunderstood the judgment. It wasn't about, it wasn't a prescriptive list of things that they had to do. It was simply aspects of the knowledge that they lacked as a diligent operator on the facts of the case at that time. And so really, we say this part of the judgment is completely misunderstood. If one looks at the points in 226, it's a small team of individuals, so there's a criticism it was too small to do a proper job. They were all located in one country. They were essentially mainly software engineers, and the SMVC was, I think, the software or design base, so they were a sort of offshoot of that. The CIG itself had the shortcomings that had been identified. They were given no active instruction to undertake searches. Well, that is potentially building upon, but it could be that those searches were done beforehand so that they clothed themselves with knowledge of the main marks. I mean, my clients had trademarks in Vietnam, registered as trademarks in Vietnam as national marks. and they were given no active instruction to take their searches. But Mr. Kim's evidence was that after the dispute started, they did start to consult the WIPO database. And really, E is important. We have, it's a point that's been slightly lost during the course of this appeal. 88% of the apps on the SGA for watches, because of course it also has smartphone apps, 88% were watch face apps. So this is what it's all about on the SGA store.
What are the remaining 12%? What are they?
Well, I guess utilities.
The watch apps.
They're what? These are smartwatch apps, so they are. Well, I've got one here. I don't want to give evidence, but
Well, presumably it might be things like a fitness tracker
yes,
that you can install on your
exactly what's on my Galaxy Watch.
phone. Right.
So there were a number of points made, but these are not intended to be applicable to all operators in other cases and so on, and they don't purport to be factors that define what is appropriate conduct.
Well, I'm not suggesting that this is the be-all and end-all of this part of the case, but it's an interesting test, which since you draw attention to subparagraph E, because the judge says, I would expect Samsung to ensure that the reviewing team have knowledge of a good range of watch brands.
Yes.
Now, I think we've already established that you say that actually they did have knowledge of at least the most famous ones, and we'll put that on one side and simply focus upon the language used. Should.
It should, yeah.
Is what she's saying there. And in many ways, the dividing line between you and Mr. Alexander is precisely on that point. He says, this is simply a mantra that runs throughout this part of the judgment, that you could and should have done better. And his argument is, that's not the test. The test is, what did you actually know? And on the basis of what you actually knew, what should you have concluded?
Yes.
Doing better, he argues, is not part of the test. Now, what do you say to that?
That can't be correct, because that removes the sort of objective nature of the diligent operator test, and it confines should to only one part of the inquiry. As I listened to my learned friend yesterday and debating about whether there had to be a trademark search or whether one needed to have knowledge of the trademark number, I got the impression that my learned friend would have argued even a trademark search was not enough. What if you had a trademark search? Well, then you didn't know whether the trademark was liable to be revoked on grounds of non-use or whether there was a defence, and you're not required to investigate that, and therefore you can stop there. And so really, where do you draw the line? We say at a reasonably basic level of being able to identify, you sell watch face apps for watches, and you ought to know not just the Swatch brands, but some other quite famous ones as well. And you should know that they have some basic industry knowledge of how it works, whether they license generally or whether they've got, for example, Apple have a very well-known partnership with Hermes over with the strap of their smartwatch. It's the sort of thing that I know, I'd expect Samsung to know, if they're selling smartwatches, and if it's Apple, their main competitor. So it's not the sort of, it's not something too high as a standard. We say certainly not onerous. And given the level of detail and training in relation to some of the Samsung brands, clearly not beyond the faculties of the reviewing team. So I think we would say that is basically the question between us, whether it's sufficient that, or they should have known the basic brands, and that was sufficient.
So the key question of law is what is imported by the word should have.
Yes. May I take you then to, I think having jumped around, I can now quickly turn to the law on this. because we say if you start with the directive, the tab 3 of your under authorities JA1. There are a number of recitals that have been discussed, but the key one we say for the purpose of understanding 41 is, 14 is recital 42. The exemptions from liability established in this directive cover only cases where the activity of the information society provider is limited to the technical process of operating and giving access to a communications network over which information made available by third parties is transmitted or temporarily stored for the sole purpose of making the transmission more efficient. This activity is of a mere technical, automatic and passive nature, which implies that the information society service provider has neither control nor knowledge of the information which is transmitted or stored. The clearly relates to the two different exemptions, not Article 14.
Why
as
not?
the
Because it
well,
refers to storage.
because, well, it's talking about temporarily stored, which is the language from the caching one. This was the subject of...
The exemptions. I mean, there are 3 exemptions, not
Yes.
2.
It doesn't matter in a sense because the Grand Chamber said it applies to Article 14, and
Well,
it was a
and-
debate in the
but-
commentary.
But on
That's
the
all.
language of the recitals, you contrast 43, which talks about the exemptions for mere conduit and for caching,
Yes,
because you don't find that language
that is true.
42.
That is true. Another way of looking at that, I think, in the commentary was that that section is only talking about, but it doesn't matter because
The
in-
court said it applies. And
the court said it applies, and they didn't take out all of it. They took the point about being merely technical, automatic, and passive, and that is of general application. And we know that that's the first basis on which you may lose your defence.
That's your respondent's notice point.
It is, well, it is, but we don't need to go, we don't think we need to go that far. The judge was slightly more tentative about the e-commerce defence than she was in other parts of the judgment, but we say still got there in the end. So the basis for that is, sorry, I'm going to continue with the directive, that if one turns to the language of Article 14 itself,
We've got recital 46, which explains a bit about Article
Yes.
14.
consisting of the storage, upon obtaining actual knowledge or awareness of illegal activities, has to act expeditiously to remove or disable access. The removal or disabling of access to be undertaken in the observance of the principle of freedom of expression and of procedures established for this purpose at national level. I wonder if this is a point that may be coming up for my lords next week, but about overzealous notices and takedowns and so on. But and then there's 47, which is the monitoring obligation, and as was made clear yesterday, I think by Lord Justice Arnold, that the obligations are to prevent from imposing a monitoring obligation which is general and doesn't prevent monitoring obligations in a specific case or affect orders by national authorities. But just the language of Article 14 itself, we say, makes it very clear that you are not, it doesn't all collapse into a notice and takedown type scenario. We know that because if you just contrast in 1A, the provider does not have actual knowledge of illegal activity or information, actual knowledge of illegal, or is not aware, so awareness is already a broader term than knowledge, of facts or circumstances. Circumstances aren't the same as facts, they are intended to be broader, from which the illegal activity or information is apparent. So it's a much more inferential process based upon circumstances and awareness of circumstances, which sort of move the inquiry away from a specific notification on a specific occasion. Now, there's no doubt that it has to be something fairly solid, but that you get to in the end. But it is still, we say, broader in general than the first leg, so to speak, of that. 14.
Does the word illegal govern both activity and information?
Yes, I think we suggest it probably does. The word actual doesn't, though. In answer to the point I think you put my learned friend yesterday, we would say that it's not actual awareness in that sense. Actuality, we say, is a clearer and more immediate.
I ask a different question. Apparent to whom?
Apparent to the provider, rather than considered objectively and should, and that basis. So it's the point that was raised earlier about the individual reviewer versus the provider. So apparent must be the
So
party
you're
who's-
accepting that that's a subjective test, not an objective test.
no objective test through the word should.
But the word should is not here.
No, that's right.
So at this stage,
gets
we're
important.
focusing on the language.
True. Yes, it's not there in that particular language. One has to be a little bit
So
careful.
you say apparent is an objective test.
Yes.
But if it's an objective test, is objectively apparent, then it's not. Then that can't be apparent to the provider. It's inconsistent.
Yeah, as I think we've said, it's a normative test generally, as interpreted by the court, and I would assert that it is not purely subjective, because otherwise you could simply train a group of dumb people, people who did not understand what brands were and what have you.
So your submission is apparent means objectively apparent.
Objectively apparent, yes, that I think is our submission. I'm not sure there's any clear case law on this, and the word should just jumps out of two cases without much explanation, as I'll show you.
Well, but this is why it's worth looking at the language
Yes.
of the directive as you've rightly taken us to before we look at the cases. Because if the language is interpreted as meaning objectively apparent, then it becomes a little easier to understand why the court has interpreted that as meaning should.
Yes, quite so.
And it may also cast light on the question of how far should goes.
Yes, certainly. So as I said, if you've got two things that could potentially be going on. You've got your not technical, automatic, and passive from the recital, or you are been made aware of circumstances which give rise to an apparent presence of illegality. And in Google France, we have a suggestion, I think, of the first suggestion of what not being technical, automatic, and passive might mean. If you take, please, your bundle of authorities, it's page 492.
Just before we go to Google France, can I ask you this, and can I ask this, the reverse of this question to Mr. Alexander? If you maintain the judge's finding on use of the signs by Samsung, does that answer the question whether Samsung was or wasn't passive?
The tests are remarkably similar, and probably yes, I think, because you will have held, that so far as the consumer is concerned, they've appear to have made the use. But I would just say, subject to this qualification, that they seem to be asking slightly different things, because in the use case, the first question, you're trying to understand from a consumer perception angle whether it's directed from them to you, whereas and that might through various means be answered one way, whereas in this context it is much more about knowledge and control of the data and knowledge of the information, which you might gain even if you don't then make a use that the consumer sees. So it might be you might be behind the scenes making yourself liable. But subject to that, it's difficult to think of cases where you were where you've been held to use on the first question, but you somehow managed to avoid that result when it comes to the third. And certainly this case, we say, is not one of them.
Simon was trying to attract your attention.
592, not 492. Oh, of which one? Of this judgment?
Google
Oh, sorry, Google France, it's page 592 of the judgment. It's paragraph 112. Sorry about that.
Sorry, I'm lost. Where are we?
We're in the joint authorities bundle, and we are in, which one is it? 2, I believe.
Yeah.
And at page 592.
Google France.
Yes, it is there. It's right at the end of Google France. So this was the AdWords case that discussing before, and on use, it was held they hadn't used. And this may be essentially an answer to Arnold's question about the difference between use in one context and use in another. Because having held on the question of use, that this was not use in Google's own commercial communication, the court then gave a little hint that they might not be able to avail themselves of an e-commerce defence. And you get that from 113 onwards. So 113, they talk about the mere, they refer to recital 42, and they say that it only covers cases in which the activity is a mere technical, automatic and passive, and neither knowledge or control. And then you've got to look at the role played by the service provider, they say in 114. And in the general case, Google don't have that. So with regard to the referencing service at issue, it's apparent from the files, with the help of software which it has developed, Google processes the data entered by advertisers, and the resulting display of the ads is made under conditions which Google controls. But they go on to say this: it must be pointed out that the mere fact that the referencing service is subject to payment, it cannot have the effect of depriving Google of the exemptions. Likewise, concordance between the keyword selected and the search term is not sufficient to justify the view that Google has control. But 118, they say, by contrast, in the context of the examination referred to in para 114, the role played by Google in the drafting of the commercial message which accompanies the advertising link or the establishment of the selection of keywords is relevant.
That's the other way around, though, isn't it? That's saying even if you don't use, you may not be entitled to the e-commerce defence.
Yes.
Whereas if you do use, are there circumstances in which nevertheless you may be entitled?
I see. Yes, I had read that as Google might have lost the.
It might have done, even though they didn't use.
Exactly, that's the point. Yes. So even though they hadn't used for the purposes of question 1, by getting involved, tinkering with the commercial message, they might have used. Now the consumer wouldn't know that; they'd have absolutely no idea. So it might not be a breach of question 1. And the same thing when it came to L'Oreal and eBay, which you'll find at 761, at para 119. It must be 43. Is it JA3? Yeah. JA3. Again, in a case where eBay can held not to use simply by having marks of third parties displayed on their website for the benefit of the sellers. There was a suggestion that, because of course the DCJ doesn't decide the case, they're simply suggesting to the National Court what the position might be. But at 119 and 120, which perhaps I could let you read to yourself for a moment. it's actually a little bit further on. It's over the page down to 122. Yeah, it's down to 123 actually, where they talk about the specific involvement that could deprive eBay of the defence. Optimising the presentation of results, isn't it? Yeah.
Is that bit there as well, 124?
Yeah. Oh, I see. Yes, of course. Then they marry it to the diligent operator standard, and that's in 124. So, and Peterson, the post-Brexit judgment, what is worth, says the same thing. I'm not going to take my lords and lady to the Advocate General's opinion, because to the extent it was followed, it's been superseded. It doesn't really relevant. But to the extent it wasn't, we say it can be ignored. The ECJ never expressly disagrees with or very rarely expressly disagrees with the Advocate General. You can draw your own conclusions when they decide politely not to mention various things. But we say of this, the same issue. Now, if I just pick up from Peterson.
We're going to the court in Peterson, are we?
I'm going to the court, which is tab 16 of JA2. Let me just find the part number. It's 491, page 491. Sorry, yeah, 491, paragraph 113. And that's a sort of general discussion of the recital that we looked at, recitals, monitor, and knowledge. And 114 was relied upon by my learned friend. In that regard, the fact that the operator of an online content sharing platform automatically indexes content uploaded to that platform, that platform has a search function that it recommends videos on the basis of users' profiles or preferences, is not a sufficient ground for the conclusion that the operator has specific knowledge of illegal activities. And we say, well, that's quite clear because it's technical, automatic, and passive. There's no knowledge of control, or knowledge of, much less specific knowledge by a human being of anything there. But then they go on to say this at 115, as regards more specifically the second of the situations provided for. So there is a second situation, in case there's any suggestion that it's been collapsed into the first, namely the situation relating to awareness of facts or circumstances in which the illegal activity or information is apparent. The court has held that it's sufficient that the service provider concerned has become aware in one way or another. We think those words are quite important. It's really any way of facts or circumstances on the basis of which a diligent economic operator should have identified the illegality in question and acted in accordance with Article 14(1)(b). That includes, so this is not intended to be the standard.
So you rely upon that as supporting the submission that apparent means objectively apparent.
Yes, we do. That includes inter alia the situation in which such a provider uncovers, as the result of an investigation undertaken on its own initiative, an illegal activity or illegal information. Pausing there, because the second situation is when they're notified. So, I mean, that's just an example that they're giving of proactive conduct by the operator in which it has become aware of an illegal activity or illegal information.
If you go back to 113,
Yes.
they're talking about 14.1a in general,
Yes.
and they say the illegality of the activity or information must be a matter of actual knowledge or must be apparent. And then they then go on to explain what that means,
Yes.
don't they? That is to say, it must be specifically established or readily identifiable.
Yes.
So it's not. In this case, it hasn't been specifically established, or it wasn't at the time.
but readily identifiable.
So readily identifiable
Yes.
seems to be the test.
That's the test. And it's open-ended, but it is an objective test there too. It's readily identifiable. The word specific simply means, they use specific a lot, and the reason for that, we say, is to distinguish it from the word general obligation to monitor. So it's always for that specific infringement or that specific case, or if you've had a previous notice and takedown, that specific set of infringements or that type of infringement. What you can't be obliged to do is to have a sort of general roving obligation to do a lot of things, to look for
is
new
that
illegality.
why one needs to differentiate between the obvious cases and what I called yesterday the more subtle infringements, and I think you called earlier this morning the more fine-grained ones?
Yes, exactly. So you're not required to go out and do those, but frankly, if you have a system that picks up the double identity obvious ones, you're pretty likely to take care of most of the problem. So it's not about going off and doing trademark searches necessarily, unless that's part of your training and your basic knowledge. And we say that one can see the distinction between technical, automatic and passive as the sort of basic approach, and then one can see the diligent operator standard coming in the later cases, and you get awareness based upon those. Now, there are a couple of other points that I wanted to mention briefly, depending on the court's interest in them, which is the sort of Good Samaritan point that was obviously concerning the judge. There is a sort of, it's aptly described as the Good Samaritan paradox rather than the Good Samaritan defense. It's the Good Samaritan paradox. There is no doubt that to some extent an internet service or internet information society service provider who is carrying out a degree of scrutiny and knowledge of its content in order to, for one reason or another, is ironically more likely to be liable. But they make that choice. They make the choice to do that for their own purposes. And to some extent, it's an inevitability. The reason we put in, by the way, the...
This is a well-known problem in this field.
Yeah.
You say it's an inevitability. It's an inevitability of providing a system of the kind that is in the safe harbour provisions, both in the EU and indeed under the US
Yes.
provisions.
And the US provisions contain an express and very, very broad Good Samaritan defence, and it's either been rescinded or is going to be rescinded. But the position is that it's potentially open to abuse, because you can say, well, I did a bit to protect myself. I didn't want any bad stuff on my platform, whatever it was. So I got rid of the really objectionable stuff, anything by my competitors, for example. And then I didn't bother with anybody else because I don't care about anyone else. So we say these situations have to be looked at individually. A case like this, for Samsung to suggest that they were Good Samaritans when a very large part of the intellectual property part of their content review guide concerned their own trademarks, and certainly the most
But
developed
what do you say
guides.
to Mr. Alexander's point that imposing an undue burden upon operators will be counterproductive, because all it does is incentivise them to do nothing?
there is a potential danger of incentivization to do nothing and therefore notice and takedowns. But we consider that the commercial interest of the platforms in maintaining the integrity of their systems, and in particular the platform at issue in this case, I mean nothing more broadly than that. The commercial interest of Samsung in maintaining a good, unsullied, functional, and well-populated database of apps for its phone to show off its functionality will always prevail. If it's a question then of resources for them, then they are clearly, I think they're the 9th biggest company in the world or something, they can manage.
What's so troubling about these sorts of cases is that ultimately it's a question of what should the operator be doing or not doing. And courts are singularly ill-equipped to tell electronic commerce operators what they should or shouldn't be doing.
Yes.
It's not our job. All we can do is apply the law to what has happened in the past to determine whether there's liability or not according to the legal framework that's been imposed by the legislature. That's fine. But when it comes to prescribing standards of behaviour, it's not our job, and we're not equipped to do it.
Well, I'm not sure we'd necessarily agree with that, my lord, because if you don't do it, no one else is going to do it. And they're going to continue to give the companies and consumers the treatment that they give them. You know, you're dealing with a very large organisation which deals with things in a very slow way, typically, and who invokes these defences as a mantra, the notice and takedown procedures. And yet they are the prevalent means of commerce, of doing business, and they're doing rather well out of it.
Well, that doesn't detract from my lord's point.
It doesn't, I suppose. But
We're not
it's just
management consultants.
Yes, of course. Yeah, exactly. I'm helpfully reminded by my junior that, of course, the standard that we're setting in this case is simply knowledge of the second, fourth, and fifth biggest brands in watches for a company selling watches, having basic training and basic levels of knowledge. This is not something more sophisticated and certainly not anything burdensome. And indeed, it's actually not even a standard. It's simply a criticism of what was done rather than what they could do better. I think those, subject to any questions my lord and lady have, those are my submissions.
Well, what do you say about the Digital Services Act?
Oh, yes, I
Which
mentioned.
is inapplicable,
Yeah.
but nevertheless, Mr. Alexander was keen for us to look at it, although
It was
one
my
might
fault.
question to what extent it really helps him rather than helping you.
Well, I relied upon it, and I began to regret having done so. No, that was not actually the case. The position with the Digital Services Act, of course, we felt we should update the court to know what had happened with these particular exemptions. And the first point that came through from that was that the legislature had copied out the previous, the e-commerce directive is old, and
Do you, want
they
us
didn't
to,
touch it.
do you want us to look at this or not?
You could look at one. I would take you to one provision. So it's your JA1,
Yeah.
and it's the provision I think my learned friend took you to, just because I relied upon that.
Right, so tab 5.
So the first point is that they kept verbatim I believe verbatim, but certainly almost verbatim, the exemptions that exist, and that rather suggests that they're doing rather well, and that the court, and they did so expressly on the basis that there was a lot of ECJ case law that would be rendered redundant and things had developed rather well. And so the balance seems to be struck.
This is Article 6 you're looking at, is it?
It's Article 6 is the specific provision. Yes, that's the hosting is the specific provision that's been copied out. And then Article 7 was the second point that I think's been highlighted. And that is a sort of a form of the Good Samaritan defense. If you just read that, or sort of the Good Samaritan point. And we wanted to show the court that just so that it was up to date with what was going
Yeah,
on.
so this is one of these points that cuts both ways depending on which way you look at it. So Mr. Alexander says this shows that as a matter of policy, we Samsung should not be penalised for undertaking our own content review.
Correct.
And the counter argument is this shows that the legislative direction of travel is towards encouraging operators to be proactive rather than reactive.
I would agree with both of those
Where
points.
do we as courts in the UK stand?
Well, we would agree with those points, and we would say that the court can be aware of this and note it. But we would say that it is telling as well. So, in other words, it's quite right that you should not per se be penalised for looking. But it depends what you look for, how you look, and what you're in what way you're being penalised. You can still lose the defence for looking. We know that, and this doesn't actually detract from that. But this has a lot of requirements to it that we say Samsung just simply would never have satisfied. Apart from anything, it says diligent manner. Carry out voluntary own initiative investigations and other measures aimed at detecting, identifying, removing, disabling access to illegal content. And so we say, in including with complying with the requirements of union law, that would include the trademark law and national law, in compliance with requirements of this regulation. So all that is saying is this Good Samaritan point goes some distance, but it only goes so far. It's not a trump card, and that's the problem, and that's the way that it's been deployed.
It just makes clear that the diligent operator
Yes.
case law has been incorporated.
Yes,
in
that's
legislation.
the other way of looking at it, of course, is the use of the word diligent expressly cross refers to that word as used in the case law. But whether it be unconstitutional for you to mention it, I'm sure it wouldn't be, but as a piece of legislation, it's significant that it copies out the existing and binding provisions from the case law, from the previous legislation. Just a note. Oh yes, there's a note. There's the one point I've overlooked, and then I really will be finished, is the points made by my learned friend about they didn't conceal these apps, they were findable, and so on. The evidence in the case and the findings by the judge were actually quite damning on that point.
They were findable, but with difficulty.
Yes, I mean with great difficulty, and in fact, the evidence from Samsung was, and this is recorded in the judgment, that it didn't actually throw up all of the results. It never did. It was a sort of best result. And then they were in different categories, as the Mintz report found. Indeed, they were, and you had to buy a Samsung watch, as you wouldn't sort of have an interface on your desk, like a professional legal team. You had to sort of do it on the fly, so to speak, with one of these devices. So that was not the case. It wasn't searchable. And in fact, Miss Ober, the witness, contrasted that with the practices of some other platform providers as being well below the standard. Those are my submissions.
Is there anything further? I think you've covered it, but is there anything more you wish to say on your respondent's notice on this issue?
By having at least touched upon the Good Samaritan point, I've sort of strayed into my respondent's notice to some extent, but no, not specifically. I think we would just rely on the judge's basic finding, which is that...
Well, I need to be clear. Are you relying on the respondent's notice or not?
I'll just remind myself of the way we put it. mentioned that by not being technical, automatic, and passive,
Yeah. that's-
already we're in trouble.
Well, exactly. So as I understand it, you have 2 points. One is you say they're not within Article 14.1 in the first place, for the reason you've just stated. And that, as I understand it, is your respondent notice point.
Yes.
And then secondly, you've got the point where you succeeded before the judge, which is in any event there's non-compliance with paragraph A.
Yes. Correct.
Okay, so you've covered everything you wish to cover.
No, I think so. Yes.
Thank you.
Yes, Mr. Alexander.
May I deal comments in the following order? First of all, e-commerce directive on Article 14.1a, so responding to the points made on our appeal. Then make some brief comments on the respondents' notice on Article 14.1. Then deal with the use in relation to, and it makes sense to do use in relation to smartwatches first, and then use in relation to Samsung at the end, so as it were in reverse order, if that's convenient for my lords and my lady. Before we get into the detail of that, it's probably worth just having in mind, since we went to it this morning, just a few points on the supplementary material, because that will go through some of the submissions that I make, and I don't have to keep going back to the bundle. We can deal with it all in one go. Is that a convenient way of
Yes, by all means.
dealing with
We're
it?
going to supplemental 1 or 2.
If we could start at supplemental 1, which where we were looking at the watch faces, and your lordship, my lady, have seen the consumer journey in relation to the watch, and also the different approach to the consumer journey
Yes.
on the when accessing on the phone. Those are 2 different kinds of use. You know, obviously the uses are similar, but they are to this extent different, and the judge identified that difference. That in the case, at least, of access on the phone, there is, we would submit, really a clear indication of a third party, and it's true that it's not necessarily always apparent that may be the undertaking, but a third party is identified in that context as responsible. Secondly, even in relation to the access via the watch, as you can see, I think from supplementary 11, I think it was a point that my learned friend in fairness made, because the nature of the interface has changed somewhat over the period, one sees there that access to the, in this case, the TSA Navigator, does identify the origin in this sense, that the seller is German Gomez. Now, it's possible
Well,
that
that's not accepted.
no,
because-
I was just coming on to that because of the point on that it might be regarded as the designer. However, we respectfully submit that the fact that it might be regarded by as the designer is not enough to say that that's the ordinary way in which that would be perceived. But my general point, my lords and my lady, is this: that one does need, when one's looking at the trademark matters and in our submission, the e-commerce matters, at least at some level, to look at, as my Lord Justice Arnold put it, matters on a case-by-case basis, identifying the relevant individual uses. That general point also applies to the issue of always on or not always on, which was also discussed this morning. So if, for example, you look at the next tab, so starting at 17 and 18, what you see, well, in 18, is that although an AOD is shown in some cases showing the mark, what it appears to be the case, and I accept these pictures are not very good pictures, is that the screen is very significantly dimmed in any event, even if it's
From
not
your perspective,
not
is
blurred.
that you're making these submissions on facts without any findings.
Yes, and I accept that. However, there are some pages or cases where that is absolutely clear, and one can see that. And this relates to the point that I'll come on to in relation to use post-sale use. So if one goes on to the next page, supplementary 20. Sorry, the page after that, supplementary 20. You'll see that the swatch mark is simply not there when there is an AOD display. Supplementary 21, I accept one can't really make a lot out of it because the image is somewhat blurred. But the next one, supplementary 22, it's clearly not there. Indeed, no aspect of the design is there. And when one comes to the Tissot or Tissot, I'm not even quite sure how it's preferred to be pronounced here, you don't see any brand at all on the AOD display. Similarly, the next Tissot AOD display, there's nothing displayed by way of the brand. Now, there isn't a similar AOD display in relation to supplementary 25, but again, supplementary 26 does look somewhat dimmed. I admit that the photographs are not particularly clear.
But surely in 26, one can clearly see swatch.
Yes, there I think it's right that one can see.
Maybe because it's a better photograph, as one can see from the bezel.
It may be. On that point, and my lords may say, well, that doesn't really affect the position at the moment, although we do say that it is a relevant factor to take into account. I think that particular swatch.
Well, suppose for the sake of argument that we accept the submission that in some cases the mark, the sign equivalent to the mark is not visible
Yes.
in always on, and in other
Yes.
cases it is. What do we do with that?
Well, we would respectfully submit that the right way to approach it is that, well, there are two ways to deal with that issue. The first way is to say, well, they're not. If my lords and my lady are with me on the general point that one needs to look at this aspect of alleged infringement on a case-by-case basis, and if the basis for the finding of infringement is one that is that relies on third-party viewing the mark and the availability of the mark because it is always on, then that is, in our respectful submission, an important factor to be taken into account in
So what do we
determining
do?
whether or
We
not.
have to send it back to the judge for some findings.
Well, either it will be sent back to the judge, or one would say, well, this is an issue that should be dealt with insofar as there is relief to be dealt with on the inquiry. I'm not quite sure whether one can exactly do it in that way, or my lords and my lady, you could make a decision yourselves, but which is the other option. But we would respectfully submit that what one can't do is simply ignore that fact, because not only the judge regarded that as a factor of importance, but in putting points to me by my Lord Justice Arnold yesterday, that was one of the points that was put by my lord. What about the fact that these displays are always on? Well, it is potentially a factor. It does differentiate the situation in our respectful submission materially from the position with respect
The
to.
judge didn't deal with this because on her approach to this, to the question of use in relation to what, she didn't need to.
Exactly.
Because on her approach, there was use in relation to the watches, even disregarding always on. And always on her approach is just a stronger case where it's present.
Yes, and our submission is that the approach that she took, which was to take, as it were, a blanket approach to the analogy with the post-sale use, other post-sale use cases was the wrong approach. If the court concludes that actually that was the right approach, this point doesn't arise, obviously. But if you are with me in relation to the point that this kind of analysis, even insofar as it relies on this kind of alleged use, does require an individual evaluation to see whether it is realistic that the mark would be observed in realistic circumstances by the category of consumer to which the mark is, by reference to which infringement is directed, then in my submission it does arise.
I completely understand the argument, but to be clear, I mean, it's inherent in your argument if the always on feature is not enabled, but the user sets the timeout time to 1 minute, then that's not enough. But why should it make any difference whether it's 1 minute or 10 minutes or 10 hours?
Because it affects the propensity of the mark to be even seen by an average consumer in circumstances where the average consumer would be encountering.
Since when does trademark infringement depend on how often one looks at the alleged infringement? Take the pottery mark example. Many people will never pick up the piece of pottery to look and see what the mark is. Likewise with the corks example. Most people are probably even oblivious to the fact that there's a branding on the cork at all. The point is, it's there for those who are interested.
I accept that, but at least at that level of generality. But if if one's dealing with, as it were, the consumer to whom the mark is directed, which is primarily the person who has it on their watch, who is, on this hypothesis, not someone who is going to be confused because they encounter, is not someone who's going to think that it is a mark used in relation to the watch, because they know perfectly well that it isn't, and they know that it's a mark used in relation to the app, which were the findings of the judge, which was the starting point of this case. And the only category with which one is concerned is the third parties who might see it on someone's arm. Then in those circumstances, that narrow set of circumstances, this point is of relevance. I was jumping ahead in just showing you why the argument mattered, but that's the key point in relation to this aspect. And we respectfully submit that the judge didn't analyse it in that way, and that is the way that it should have been analysed in relation to the use in relation to smartwatches. I see the time. Well, it will be
Yes, is that
sensible to
convenient?
take it up to 2 o'clock.
Yes, indeed. 2 o'clock.